Good afternoon, everybody. Today is February 20th, 2025, and we're here today to talk about embryo litigation. And I want to introduce our two fabulous guests. So first, we have Melissa Neckers, who is a Michigan attorney at Miller Johnson in Grand Rapids. She's been there since 2001. I have known Melissa at least since 2007 when we worked on the same adoption case together. And ever since then, I remember we were both pregnant at the same time, and she's just been a fabulous resource for adoptions in Michigan over many, many years. But in the past several years, she's really honed her practice in onto the assisted reproduction and surrogacy work and was really instrumental, I think. I don't know if she agrees, but I think she was really instrumental in the passage of the Assisted Reproduction and Surrogacy Parentage Act, which is brand new in Michigan. And then we also have Alexis Cirel, who is a Manhattan, New York City attorney. But guess what? She's now licensed in Michigan. Yay! So Alexis has a great reason to be coming to Michigan, even though her practice is family law and surrogacy type issues in New York City. She also went to Michigan, the University of Michigan, for undergrad and law school. So welcome back to Michigan, Alexis. And today we're talking about embryo litigation. It looks like Alexis wrote, there she is, okay. We're talking about embryo litigation. I want to remind everybody, if you have questions or comments, we might even be seeking some of your input. Feel free to use the chat or the Q&A buttons. I will be monitoring that. I really want today to be about Melissa and Alexis sharing their knowledge and insight on this important topic. And if for those of you who don't know, the family law section did a webinar roundtable last month on surrogacy. So this is a little bit different because we're talking about the litigation that happens over the embryos, which is kind of a tangential or related topic, but not the same topic that Melissa and Alexis participated in last month. So today is about embryo litigation. And we're going to start with I think the reason I was interested in the topic is not only just because we've been talking about the Surrogacy Parentage Act and all these things, but over the years, we've had occasional cases in our firm where parties are fighting over, on appeal, they get to appeal over embryos. And right now, there's a case currently pending in the Michigan Supreme Court, the Markiewicz matter, which came out of the Court of Appeals to decide basically two divorcing couples. A divorcing couple is trying to decide how to dispose of the embryos, and one party wants to have possession, probably to destroy them. The other one wants to keep them in case she wants to have a baby down the road. So there's this whole big conversation that's happening in Michigan right now. So first of all, welcome, Melissa and Alexis. And do you have anything you want to say at first? Because I'm sure I've botched something at this point. So Melissa, Alexis.
No, I'm just glad to be here. Thank you so much for inviting me, and I'm really grateful to Alexis too for joining us, since she has done a lot more embryo litigation and been involved in a lot more family law cases that involve embryos than I have been. So
yeah, and both ladies here have the family law doing domestic relations kind of cases as well, not just focus on this embryo and surrogacy side, but this is kind of, I think both of them have really found their passion in that area. So I guess we don't really have a lot of law in Michigan. And so I think that's why it makes it an interesting conversation. It's why it's such an interesting case in the Michigan Supreme Court. The family law section did take a position, but it was more about, hey, there should be some equitable factors to govern this because there's really not law to help us decide. So let's start with what happens when a couple is getting divorced, they've created embryos during the course of their marriage, and they have to decide what to do with them. Is there a starting point of where an attorney representing one of the parties should start to figure out how to resolve that situation?
I think I cut out for a second, but I just wanted to say hi and thank you for having me too. And yes, it sounds fancy when you say a Manhattan lawyer, but my office is there, but we do the same work. We all do the same work. And yeah, I do practice in what you call family law. In Michigan, we call it kind of matrimonial law. So, divorces, custody, but also a lot of work in assisted reproductive technology and surrogacy stuff. So I have had more occasion probably to interface with the embryo issues, just because we have a recent law on the books in New York as well that's similar to the new law in Michigan. So I've had some experience, but I think it's one of those subject matters, like many areas in law, where there aren't really answers. There's just interesting debate. And, we can kind of look at trends, but it's all such a new area of law that it's still kind of a nobody really knows category.
Agreed.
Right.
I agree
So-
with that.
And maybe the starting point, and I asked about like how do you start the conversation with somebody who comes into your office, as an attorney, somebody coming to your office and they want to get divorced, but they have embryos and they don't know what to do with them. What's your starting point there for figuring out what to do?
So I think even before that, a good piece of practice pointer to take away too is like, ask if they have the embryos. So many times I will have clients come in and we do an intake of the assets, and we talk about how many children and what child support might look like, and separate property, marital property. And sometimes nobody thinks to say, do you have stored genetic material? Right. And it wouldn't necessarily dawn on a client to say that as part of the marital estate, because is it property? Is it, a child? We have to figure out first what it is. And so people don't necessarily think to disclose it. So in the first instance, I think always important to ask that. Also, even earlier on, at a prenup stage, right? If you have prenuptial clients coming in, they may or may not already have stored genetic materials, and they may or may not know that they will. So you can even talk about it and think about it at that stage.
Okay, so I have a question about that. So you're saying like a prenuptial agreement might happen between a couple that's about to get married because one of the parties has previously created stored genetic material?
Well, maybe not because,
Okay.
but just like when you're, preparing a prenup for a client, you're asking, what is the scope of your current assets and liabilities now, and your future spouses? And then do you already have joint property? At that
Right.
point, also, do you have stored genetic material? Because again, we're making it up a little bit as we go, how we would deal with that in the prenup. But if it's there, acknowledge it. Think about, if you can address storage costs in the future or something. You're already addressing disposition, and distribution of other assets that are hypothetically acquired during the marriage. So at least know it, at least get it out there, and have your clients think, oh, maybe I should go back and see what forms I've signed at various clinics where I have stored stuff, and just at least know it. That's step one.
Okay. I just the thing that's striking, you say we're kind of making it up as we go along, but like, isn't that kind of family? Like, we know the law, but family law, we have clients that come to us with these really unusual situations all the time, and we're like, wait a minute, like nobody thought of this situation. And including people who are drafting a prenuptial agreement, they may not have envisioned one thing or the other. So it's I guess
It's
something
exactly
that
right.
family law attorneys have to roll with the punches a lot and deal with
Right.
these unexpected developments.
That's
So
right.
so once you've established, you've asked the question, you find out there are stored embryos, that there's no like prenuptial agreement that's governing what happens. What's kind of the next step in the process as far as like, where do you go to figure out who gets the embryos?
Yeah.
Or does a court have to decide?
Right. So the first step is always to find out where the embryos are stored. So they're either going to be stored at an IVF clinic or a storage facility that the IVF clinic offsites to. And there are going to be forms. People will tell you they didn't sign forms. They signed forms, right? And they are out there, even if your clients don't remember signing them, don't have copies of them, they are there. No IVF clinic is going to go forward with creation of embryos without you signing these forms in one form or another. So we need to see what these forms say. And they are, I call them forms, not contracts, because really when you look at them in substance, that's what they are. It's a stack of documents that are mostly consents that the patients have to complete and give to the clinic before they'll move forward with embryo creation, the IVF and embryo creation. And it covers tons and tons of stuff. It's dense. You may not even know what you're signing. But somewhere in that packet, there's going to be something called embryo disposition directives or similar. And essentially it's going to say to the individual or the couple who are creating the embryos, what do you want us to do with these in the event of the following eventualities? Usually it's death, one or both of you, incapacitation, one or both of you, divorce or separation.
So most of the forms that you've seen, they already like are putting the thoughts into the couple's head that they have to start thinking about these questions,
You have
right?
to,
Okay.
right? You have to. Now, you can imagine, and I can attest as having, somebody who has been a patient going through it, when you're at that time in your life when you're creating embryos, first of all, usually if you're the woman, you're all jacked up on hormones, right? So you're not thinking straight, and you're going into something where it's like it's the equivalent of deciding you're going to try and start getting pregnant, right? You're excited, you're at the beginning of creating your family. So probably hard to sit there in the waiting room, which is when you're doing it, and looking at your spouse and be like, gee, I don't know, if we divorce, I'm going to give them to you, or you just check boxes and you go, you sign, you go, right? Nobody's really stopping to think. So often that's what happens. And so the first thing you ask your clients is, where are the forms? Can you get me copies of all of them? You have to see what boxes they checked on those forms. That's number one.
And that was part of the framework that the Markowitz Court of Appeals established too. So there are kind of 3 different approaches that different states have taken. The first one is, okay, everybody has to agree on what we're going to do with the embryos, or otherwise they're going to stay in storage indefinitely. The second is to look for a contract, which is the forms. And then the third is a balancing approach. And so in Markowitz, they looked to the forms and they saw that it addressed death, what's going to happen if both or one of them dies. But the language it used regarding divorce was, it will be determined by a judgment of divorce or by a court. And so
Sure, that is the very last thing a judge wants to see.
right,
Like, really?
right.
Like, you're just going to let some judge decide it someday? Like, they don't want to have to decide that. Like,
Right.
please.
But it's a punting mechanism, right?
I don't blame
punt
them.
it down the road. It's like, it's like if you're resolving custody and you say, like, well, if they can't decide, they'll go to a parenting coordinator. No, we need a more definitive plan, but yeah, that's often a lot of forms now are saying that.
And so then the next step, and maybe this is jumping ahead, Lisa, but the next step after that is to treat it like property, to look at the Sparks factors, but then add 5 additional factors, because it's obvious that embryos are not the same as like a dresser. They have the potential, at least, to be human life. And so we have to treat them differently.
So these were the factors that were discussed in the Markowitz opinion, right? And they came from, I think, another state. I offhand don't remember which state. Maryland, yeah. And I think that's the issue that's currently before the Michigan Supreme Court. And I just remember that the family law section's position was basically, hey, adopt these factors or adopt something that has some sort of balancing test or factors that we can look to solve this problem. So that leads me to a couple of different questions. First, stepping back a minute, you talk about maybe if you already have an embryo and then you're getting married, you can have a prenup that addresses it. You have these embryo disposition agreements that you maybe you're looking at too closely at the time you're, doing meeting at the clinic, should, before a couple or a person decides to create an embryo, should they be maybe consulting with an attorney? I don't know the answer, but is that something that would maybe be helpful if they came to Melissa or Alexis and had a conversation with an attorney, either as a couple, I don't know if that's possible to do as a couple versus an individual, to figure out like how to protect themselves in the future and to protect the embryo if that's their goal?
Absolutely. One of the biggest things that I do when I'm, interfacing with my physician friends and folks at clinics is to say, don't guess. People are asking. Clients, patients are in there saying, oh, which one should I do? They're asking a nurse, they're asking a receptionist. Don't guess. Don't say, if you don't know, check this. It should always be consult somebody who knows, right? Consult an attorney who knows. It doesn't necessarily mean hire somebody, prepare a whole, but consult somebody, know what the implications are. Oftentimes they're wrong. Like these forms are not prepared by people who know, right?
They're not prepared necessarily by attorneys
correct.
or attorneys in
example,
that particular state, right?
Right,
It could
right.
be an
For
attorney.
example, it has, it has testamentary and estate implication, trust and estates implications too, right? There are whole things to consider about checking a box that says, give him to so-and-so if I die. Because guess what? There's something called posthumous parentage, right? Is the child going to inherit from your estate? So all of these things have implications. I've even seen forms that say, like in New York, for example, our estates, powers, and trust law says that you cannot dispose of genetic material in a will. You have to do it by separate document. We have a clinic in New York that I won't name, but literally says on the forms, if I die, and then the box says dispose of as per my last will and testament. Right. And so people will check that, but like,
So that's
not,
void. It's
yeah,
void,
can't
right?
even do it.
Okay.
Right. So it's very smart to talk to a lawyer first. Yes. Usually when I get those calls, I will recommend doing a preconception or pre-embryo creation embryo distribution agreement or disposition agreement between the two parties. Because really, those forms are just like the two parties directing the clinic what to do rather than agreement as between themselves. And when you draft your own agreement, you can you can articulate more, clarify more, put conditions, preconditions, limits.
So this is, I'm just like, questions are just like rolling around in my
Yes,
head.
yes.
So first of all, if like with the example for New York, and I know we're in Michigan, but like I think some of it we can learn a lot from other states. You said you can't dispose of them in a will under New York law, but you could do it in the separate document under, that doesn't count. Okay. So
You can put in a separate writing. Yep.
I just was wondering whether, like, I wasn't thinking about the probate consequences, and like here we are, a group of family law attorneys, and that's my people are the family law attorneys here in Michigan. Have we heard of cases where embryos have gone to court in the probate context, and like probably not in Michigan, right? But yet,
Okay. There's a case, I can't think of the name of it offhand. I can email it to everybody who wants it after, but it was an IRS, it was about Social Security benefits for a posthumously conceived child. The embryos were created, before one of
right.
the parties died. And there's all
Yeah.
sorts of limitations, and there's actually limitations in the new Michigan statute too,
Right.
that talks about it, how one can be actually determined a posthumous parent. And there are limitations time-wise in terms of, how many months after death does the embryo have to be actually born, the kids, impregnated and then a child results in order for that posthumous parentage to apply. So some,
She is licensed. I was at her swearing in. She is.
Everybody can't see the comment, but I had the same
Oh,
question
okay.
earlier today because I looked her up too, Shell, and she's waiting for the P number in the mail, but she's already had her swearing in ceremony. So just hold tight. I'll make sure to share her contact information and her P number
Thank you.
in the next few days because it's like in the mail right now.
Yes, it's probably in my mailbox. But yeah, so there's all sorts of, there's statutory provisions that impact it from probate perspective and everything too. And how would you know, right? How would you know? And why would you be thinking about when you're trying to start a family, like dying, divorcing,
So, well, except that a lot of women can die in childbirth. So anyway, definitely send that case to me. I'll make sure that people that want it will have it.
Sure.
But so this leads to my next question. I think there's something under New York law specifically about what needs to be in an embryo disposition agreement. So I wanted you to tell us about that. And then Melissa, if you have any comments or if you can tell us what Michigan law says, if anything, about that same topic. And then I also want, if you could address, Melissa, what Alexis just mentioned about the posthumous, like in Michigan law. So first, Alexis, embryo disposition agreements under New York law, and then we'll switch gears and go to Melissa for Michigan.
Great. But let's come back then to Markowitz, because there's some interesting things to say and observe about Markowitz and how that might play out in the future for Michigan. So we have a new law about parentage of children conceived through assisted reproduction, same as the new law in Michigan. And essentially, it was designed so that one spouse or partner who no longer wishes to move forward and conceive a child with an embryo that was created earlier in the relationship can transfer ownership, custody, and future parentage rights from themselves to the other spouse or partner. We were not able to do that public policy wise before our new law because probably, this is a common theme in family law everywhere, right? That you can't really absolve a parent pre-birth of support obligations. So we would have negotiation, divorce negotiations and litigation about embryos too. And it was like, one of the factors you consider is how can you force somebody to be a parent against their will, particularly when that means they'll have financial exposure, right? So one way around that was essentially that we can now statutorily do these embryo disposition agreements by transferring that. So effectively one person becomes a donor and not a legal parent. And therefore we're not violating any policy by saying this person is not just waiving any future standing to seek custody or access to a child, but also the party who's going to now be the sole parent, the sole custodian of the embryos, is waiving and relinquishing rights to seek support.
Which
is like a
which is all
donor.
fine and good, like if it's not a married couple, right? But like, do you have married couples that would agree to that scenario?
So our statute currently says, but we just recently changed that agreement is only effective upon divorce.
Okay. Okay.
But that's changing because the standard was different for couples who are not divorced. I mean, who are not married. So it would be effective immediately, essentially. And it's a way of, rebutting marital presumption. It's a way of taking out that factor of support, worries about future support so that embryos can be more easily discussed in the context of a divorce proceeding.
Melissa, can you address Michigan law?
Well, except for that, there really isn't any. So the new statute really doesn't talk about that. So I think we would have to do what Alexis was just saying, which is to get someone declared a donor after they've already created embryos as an intended parent. And I'm not sure how that would go. I mean, I have not researched it, but the definition of a donor is someone who provides the gametes intended for use in assisted reproduction, whether or not for compensation, but it does not include an individual who gives birth to a child, except in the case of surrogacy, or an individual who is a parent under the rules. So if they're creating them with the intent to be a parent, can they go backwards and then say, actually, I want to be a donor? Um, I think that's yet to be seen. I'm
Right. Not
And
sure
there's a,
that,
yeah, there's a whole body of cases throughout the country actually that address this issue.
okay.
Some
Yeah,
of
so
them,
we'll have to.
yeah, initially, not just in the embryo context, but there's a lot where there divorce cases that involved donor sperm. And that's also super interesting because like if there's not even a genetic connection, but
Yeah.
for example, if a couple during the marriage, the husband was not able to produce sperm and they jointly were the recipients of donor sperm, created embryos, and then later divorce, right? And then that the wife wanted to use the embryos, and the husband saying, "Well, it's not even my DNA." Um, and she's going to come after me for she's going to come after me for child support. And the courts are saying, yeah, but you presented jointly to
Right.
the IVF clinic as patient and partner intending to be a parent of the child born from this donor sperm. And so it's a real mental gymnastics of, where does genetics, intent, gestation, all of these things, how does that play into your rights and obligations as a parent?
Yeah, and you can't have it both ways, right? You wanted to be the intended parent when you agreed to this, and you didn't want anybody to look at the fact that it wasn't your genetics.
Right.
And that really complicates things if you do look at the genetics. So we have to have I think you have to look at the intent when it was
Right.
created, unless you have a statute that then allows you
Right.
to
Right. But
change your mind.
the fact that the Michigan, it doesn't specifically say you don't have an analogous provision in the Michigan statute that we have in New York, it doesn't mean that that I wouldn't still advocate embryo disposition agreements.
Oh, sure, right.
Yeah, absolutely.
Yeah.
I absolutely would. I mean,
And that I think that's what Markowitz is working towards too, is that
exactly.
we have to honor the agreements that were made by people, especially before they were in the throes of a divorce.
Yeah.
And if they don't have that, then we have to look at all these other factors, which are things like, why did they use um, assisted reproduction in the first place? What other options do they have for becoming a parent? Those kinds of things. So that was your first question, Lisa. What was your second question? Oh, embryo disposition agreements.
it
Yeah,
was
I
about
think,
yeah.
yeah,
I think you've
yeah.
addressed that one. The other question I had, and then I have a whole nother topic and a question that ties into the next topic I had planned anyway. The posthumous creation, do you remember offhand the time limits under the Michigan statute?
I think it's
I think it's
36 months.
36 months.
Yeah. And then 45 months for the birth of a child, maybe.
So if the embryos are used 5 years later, they won't be the child of that deceased person. But
Right.
even if it's 2 years, 3 years later, it still could be qualified. And I wonder if that ties in with the IRS decision with the Social Security benefits.
Yes, it does. There's all different timing, and right. Essentially, and it's for like, what does that mean to be a posthumous parent? It's not. It only applies really. We're talking about inheriting from an estate. Going back to just for a moment on the Markowitz case, what's interesting to me about the decision is that it's a little different. The balancing test that is articulated in that is a little different than the balancing approach articulated in other decisions in other jurisdictions, in that it starts with factors that are very much property focused, right? So in the first instance, you're looking at the same factors that you would look at to distribute marital property. And that's a little different because, you know, a lot of the other cases are talking about those other additional ones, like Melissa just referenced. Why were they going through assisted reproduction in the first place? Is this one party's last chance at a genetically linked child? You know, those were almost articulated as a secondary consideration, the way I read it.
They are, yeah.
Yeah,
The first
yeah,
the
yeah,
first ones are sparks factors, which
yeah,
are our marital
exactly,
property
exactly.
factors. Yeah.
Right. And
Totally.
not every jurisdiction will treat
Okay.
embryos as property. Many
Okay.
articulate them as not.
So this is like actually my next topic. So thank you. So I was like, what's the status of the law, the legal status of an embryo? It ties in with a comment that we had through the Q&A, which I don't think everybody can see, just the three of us. There was this case that went to appeal like 3 times, Karunji versus Ejelou. The person who posted it is Daniel Weberman, who's a Michigan attorney. I believe he represented I don't remember the facts. I don't want to botch the facts. I know my office represented the mother in one of the appeals, but I don't think it was me personally that worked on it. So that's why I want to be very careful not to say anything that's incorrect. And Mr. Weberman, I believe, represented the other side, but he pointed out in his post to us that the question of the legal status of the embryo is like open. It's an open question around the country. And he also pointed out in the context of that case, the Karunji case, the one party, I think it was Karunji, had asked the probate court to appoint a GAL for the embryo. And the court said, no, it's not a person. You can't appoint a GAL for a property, right? Or it has to be a person. It's a pre-person, I guess.
Right.
So anyway, but that brings us back to the whole conversation that you were just starting to dive into about legal status and what's like, what is going on around the country. I feel like from law that I'm familiar with in Michigan about fetuses, and the property like discussion in the Markowitz case that uses a lot of these property factors that in Michigan it's considered property or maybe quasi property, like Melissa said. But what's really going on in the rest? What's going on? What are the trends? Can you tell us, give us any insight of that?
Yeah, well, I mean, I think we can just also link it to what the body of jurisprudence is on embryo you know, dispute cases there are out there across the country, this is why the courts are articulating these legal standards, right? Because they're saying in many cases, well, we're not going to look at traditional marital distribution factors, and we can't look at traditional best interests of the child factor as if it was a custody dispute, because that's treating it as a person. And so, like you said, it's this quasi in between entity that we have to develop a whole specific new legal standard.
Whole body of law, right?
Right.
Exactly.
Like Melissa said, the potential for human life, right? That deserves its own legal standard, and that's how these standards have developed. Yep.
Yeah.
Okay. So there's 3 main approaches, and one is the strict contract approach, right? Like look at what the form said or look at what an agreement said between the parties. There's this balancing approach, but then there's also some jurisdictions that apply what they call a contemporaneous mutual consent approach, which kind of leaves people in limbo and then leads to a balancing approach itself. But it's essentially saying, doesn't matter what you said at the time you signed those forms pre-creation, it's do you agree now? Do you consent now? And if you don't, we're at a stalemate. And then you move to balancing. So, you know, that's why these different legal standards have developed. And in terms of like this, a personhood trend, I think that's probably, Lisa, what you were more
Mhm.
referring to, right? Like we have to be very careful, particularly in this political climate and legal landscape, that we don't want to attribute personhood to embryos. We don't want to say that life begins at conception, because that has, could have real far-reaching negative impacts on IVF in general, on, abortion rights in general.
Mhm.
And another thing about the property issue is that in the Markowitz case, the the parties conceded at the trial court that it was property, that the embryo was property. So that's why they went there. They never got to, is it property? And that might make this case not very helpful going forward, because we still don't have a decision on whether an embryo is property or not. We just know what to do if they agree that it's property.
Right. So whatever the Supreme Court ends up deciding, I'm assuming it's going to be an opinion. There's going to be an arguments at some point. We're obviously going to keep an eye on it, but like it could, the fact of the matter is, because in the context of that specific case, they conceded it was property, it could impact the analysis, I guess.
Right.
Right.
Totally. Yeah.
Or application at least to other
Right.
cases. And I did want to point out, there was a case in the child welfare context. I think it was in re Semineta. I have to go look it up, but this was from last year, where there was abuse in an abuse and neglect context. A mother gives birth at the hospital, and they took her baby away. The CPS took her baby away at birth because the child was born with drugs in their system, and they said it was child abuse because the mom was, intaking drugs during the pregnancy, and so it was abuse of the child. Well, the Court of Appeals reversed that and held, in the context of that abuse and neglect context, that a fetus is not a person. They're not a person until they're born. So that kind of, it has a lot of implications in the child welfare context, but I think it also has some analysis application here, and I believe it was a published decision. So that's what we know, at least. All right.
There's a lot of crazy offshoots of all of this, I'm sure.
So I think one of the interesting things, and again, I don't really know that much about the Markowitz case. I just kind of have to keep an eye on things because I'm the chair of the family law section. But one of the interesting things, the arguments I've heard, is that, you have two people that can't agree they're getting divorced. They created the embryos when, at the time they created the embryos, their intent was to be parents, right? And now they're getting divorced, and one person wants, I presumably, to destroy them, and the other one wants to keep them just in case she wants to have more children down the road. And I think in the facts of that case, it was the DNA, it's her sister's eggs that made the embryo. But there's this whole conversation that the family law section did not go down that path. But there's all these questions about, well, if mom is awarded the embryos and decides to have a baby, maybe with another man or on her own, and then he has this guy is going to have a person in the world that is half his genetic material that he won't have any kind of relationship with, or will he be forced to have a relationship with, or it's even more complicated because they already have like 3 or 4 kids together. And so, like, what is this one child who was created from this embryo not going to be his child, but yet he's the parent of these other 3 kids who are the siblings of the same person? It's like, so it's a can of worms. It's just so many worms coming out of this can. And so I thought both sides had some really good arguments about, like, the scope of what the courts really have to think about when you leave it in the hands of the court, because in the case of, hey, the court's going to decide.
Right. Well, I mean, but we can look at trends, right? Like, so we started out by saying there's no answer, nobody knows, but we can look at trends, and across the board, the trend is that when called upon to make these decisions, courts will favor the party who is not seeking to use the embryos to conceive. So whether it's keeping them stored frozen, in perpetuity, or just award, in which case they're not necessarily awarding them to anybody. They're just saying, it's status quo unless they can consent. But the sentiment is forced procreation is disfavored. Now,
And the ACLU did an amicus brief making that argument that you really have to put a lot more priority and emphasis on the person who doesn't want the embryo or the pregnancy to occur than the person who does.
I'm trying to read the.
Oh, there's so many comments. And they're good. Like I'm just trying to get my head around this bill proposal about making a fetus tax deductible for tax purposes. Like, I'm just trying to think, like, the reason you have a tax deduction for a child is because you have, like, you're raising a child is expensive, right? I guess. I mean, I'm just trying to think of the rationale. I guess, and my question also is, an embryo different than a fetus, right? Is an embryo, a fetus is later in the process? Like, there's a I am not a scientist,
Right.
but like somewhere in the process, an embryo becomes a fetus, but an embryo is not equal a fetus, right?
Right.
Okay.
An embryo has to be transferred into a uterus to become, and then implanted. So
Okay.
the implantation piece is a part
Critical, yeah.
Yeah, and a fetus has already implanted is somebody's already pregnant with it.
Right.
And this is what was shocking and concerning when the Alabama decision came out, because in the Alabama decision, as you know, embryos, not even fetus, which there's a sliding scale of when you can argue that is human, embryos were treated as human life, such that a involuntary
an embryo in a glass jar, right? Like
right,
at the clinic.
exactly,
Yeah.
exactly.
Frozen. Mm-hmm.
Right. So it's conceptually it's difficult, right? There is no right answer, but because it has implications that are really can really negatively affect people's constitutional rights, we have to be careful not to attribute life where it isn't, right? So I even find myself all the time when I'm drafting surrogacy agreements, right? We're talking about, you know, the parents, the intended parents having decision-making rights while the surrogate's pregnant, right? And I sometimes I'll write, you know, decision as to the child. And I said, no, it's not a child, it's a fetus. Change that, right? And so the language, the nomenclature changes after the baby's born. Then we're talking about rights as to the child. So we have to be deliberate in distinguishing embryo, fetus, child.
Very valid point, which I wouldn't say that I have thought through enough.
Right.
So it wasn't a thought, it was a middle of the night gasping for air.
Yeah, no, I can see.
Oh no.
Yeah.
So I'm just trying to think with these cases where there's a disagreement, like what if there's two people, one wants to keep them to use them down the road, the other one, what would they just in perpetuity stay frozen at this clinic, and like are they paying an annual fee? Like I have no idea how it works. Can you just educate us just in like a minute about how the process works from the IVF clinic or wherever they're being stored? Is that something that they have to pay an annual bill, and what happens if their credit cards decline and they don't like, can you explain to us how that works?
Sure. Melissa, do you want to do it?
You
or
go
you
for
want
it.
to?
No.
Okay. So basically, like I said, right, no clinic is, well, no good clinic worth its name is going to move forward to create embryos or even do an IVF cycle without a bunch of forms filled out, one of which is this embryo disposition form between the two people. But there are other forms in there that talk about cryopreservation and that essentially tell the patients what the clinic's policies are, how long they will keep them on site stored, at what point they will send them off site to a storage facility, and what the costs for all of that are. Generally, there's also a warning in the forms to patients that after 10 years, if they haven't been directed otherwise, they will thaw and discard the embryos. 10 years is usually the cutoff point, but but
Oops.
oftentimes
He's coming back.
about that too, right? And these embryos are
We lost you for a second. Right at about 10 years is usually the cutoff, I think.
yes, yeah. But in any event, yes, you will get bills. You get annual bills. I think the last time I checked, it was $1,000. And oh shoot.
You're still there.
Oh, okay. Sorry, I thought I froze again. Yeah. So right, I've read some decisions that essentially say the court says, no, we're not going to decide, but the party who doesn't want to destroy them, we will put you on the hook for the storage fees, so at least there's that. And then that's it. I don't know that they may send mailings at the time where they decide to send them off site, because they only have so much storage at the lab at the clinic location. I don't know though. Sometimes I think they just send them off site without actually giving notice, in which case that's a whole other host of problems. But with particularly after the Alabama case, for example, people are panicked that if they have stored embryos in a state where there could potentially be legislation or case law coming, like the Alabama court decision that says the embryos are human lives, or the potential to go there. So we've seen people like a mass transfer shipping of embryos to safe haven states, like Colorado has a bunch of facilities now that I know people are sending embryos to. But yeah, you pay for that.
Yeah, I was wondering also if there was certain, and I think Michigan's probably a welcoming state, but I was wondering if there's other states besides Alabama where it's just people just aren't doing IVF there. They're going somewhere else to do IVF.
I think for different reasons. I think for different reasons, different for third party reproduction with surrogacy, for example. Also, it's particularly problematic to go to states like Texas or Oklahoma, because they have aiding and abetting provisions in their anti-abortion legislation, and so that could potentially expose not just the provider who performs an abortion to liability, but anybody who aids and abets it. And while I haven't seen actual precedent on this, the potential is that the attorney who drafts the contract that says that a surrogate will travel out of state for an abortion if necessary, that person could be potentially liable. The agency could potentially liable. So I think for different reasons, certain states are worrisome.
So I have one, and I think this has been addressed, but just to kind of have a clear point to it, is there in Michigan, is there a marital presumption applied when a married couple creates an embryo, like a marital presumption of parentage?
There is in the vital records portion, and there used to be, I think it's always been in vital records. So there has always been a marital presumption that the person who gives birth and the spouse are parents.
So regardless of where the embryo came from, right? That's
right, which is part of why we needed the law to change, because that was resulting in surrogates being put on the birth certificate, and then the surrogate's husband also being on the birth certificate. But the new statute, or the amendment to the statute, changes the language to no longer say husband or father, and to be gender neutral. But I don't think it changes the presumption. I have to admit that I have not dug too deeply into that, but I think the presumption is still there, that because what it used to say was that if a woman uses assisted reproduction and she's married, that her husband is automatically also the parent. And I think all that has changed is the gender language, but I don't know that for sure.
So it's kind of
And in
switching gears, but go ahead, Alexis.
So I was just gonna say, and in the new statute, there's a lot of direction in terms of spouses having standing or changes in marital status affecting, for example, the enforceability of a surrogacy arrangement. So it's dealt with, and rightly so, which is so great about your new law, is that, you know, we do think differently about affixing a presumption of parentage when assisted reproduction is involved.
Right. I wanted to talk for a couple minutes about the context where we know that the embryo cannot come from the couple, right? Because it's maybe a same-sex couple, so maybe one part, maybe the egg came from the couple or the sperm came from the couple, but it can't be both. I think there's some special aspects involved still with that. Melissa, can you address some things that have to be done differently because of that context?
Yeah, well, so that was another part of the problem previously, is that well, there were a lot of problems. So in same-sex relationships, some counties, so first of all, there's a presumption that if you're married, regardless of whether you're married to someone of the same sex or not, that your spouse is the parent. That allowed some courts to say, okay, so you don't need to do a step parent adoption because you're married, because you already have this presumption. But then other counties said, you know what, we're worried that you don't have a court order, and what if Obergefell gets overturned, or what if you know, a birth certificate isn't an actual parentage order, it's just evidence of a parentage order, and so you really should have a court order. And so we're going to let you do a step parent adoption, even though you were married when the baby was born. That caused all kinds of uncertainty depending on where people lived. And so now the Acknowledgement of Parentage Act allows parties who have used assisted reproduction to either do a record stating that they're both the parents, like an affidavit of parentage or that kind of thing, or an agreement prior to the assisted reproduction taking place, or prior to conception.
When you say a record, do you mean like a document that's filed with the state of Michigan, like our AOPs filed with the state?
An AOP does count as a
Okay.
record, but when we were talking before, Alexis said that in New York, the records end up being kind of a lot of different things, right?
Well, the way it's played out is a record is purposefully vague, right? So a record could be a clinic form, a record could be an affidavit, a record could be a donor agreement, a record could be an AOP, but it's just, I think it's looking for some form of evidence in writing.
And our resident ROPA expert, Liisa Schmidt, just pointed out that MCL 722.1433F has now defined a presumed parent as an individual who is presumed to be the child's parent by virtue of marriage to the child's mother at the time of the child's conception or birth. Marriage to the child's mother. So that doesn't address the situation of it. Pardon?
I think that it's supposed to, marriage to the child's mother, right?
Right, marriage to the child's mother. But that,
Right.
what if you have two men that are married to each other? Like, it's gonna have to be a surrogacy situation, I guess. So that won't matter.
Well, right.
Yeah.
So that's why we're in the assisted reproduction statute is its own parallel thing, right? It doesn't, yeah, that's under the Surrogacy Act, right?
Yeah. So she was quoting, I thought it was, that's not ROPA 722.1433.
I think that is. But you also, Yeah, the first one is ROPA, but
She's pulling the equivalent now, I think she's
right,
saying, which I could.
ROPA
Thank you,
also
Lisa.
says, ROPA says you can't use ROPA if you can use the Surrogate Parentage Act.
Okay.
So
Okay.
you either get to use one or both. You don't use both.
Right.
As a matter of fact, well, I always put this in my agreements too and everything, but it's clearly articulated in many places, like assisted reproductive technology statutes do not apply if a child is conceived through sexual intercourse. That
It says that.
automatically exempts that
Mhm.
from those standards.
Okay. And then, so an action may not be brought under ROPA. I'm just reading my notes. If assisted reproduction already determined under the Surrogacy Act. That's exactly what you said. And that's what Michigan says as well. Do either one or both of you have, we only have a few minutes left. So do either one of you have practice pointers for the attorneys in the audience? I know Alexis,
I
you
love
have some.
Alexis's practice pointer of asking in every situation, do you have stored genetic material? I mean, yeah.
I mean, I have, yeah, we have court forms for net worth statements in New York, and I have been for so long trying to encourage our OCA to add, because we have an expenses section and the liabilities and assets under some other category. I don't care, miscellaneous. Put in that to at least prompt people to ask, right? Do you have stored genetic materials? And also, are you planning to, right? So it can't hurt to get ahead of it. First, I think my practice pointer really is first and foremost, don't rely on what a client says they think they checked the box, a box at a clinic. Get the forms. They don't always remember. Also, the
Do you have
clinic.
to subpoena those? Or like how
No,
difficult is it to
no.
get?
It's they're their own medical records, right?
Mhm.
They can ask the clinic for it. But also they will have to do it each time they create embryos. So if they did multiple cycles, there's going to be multiple forms. And yes, you guessed it, oftentimes they check different things each cycle. So that's to me the biggest practice pointer is get all of those, get the entire medical file. I don't care if you throw out the stuff you don't need. See what they wrote, because the last thing you want to do is find out that somebody undermined their own intent in a later cycle.
I think I have to add one from today. Like, talk to an attorney before you go to the clinic in the first instance. Like, I don't think it's not like litigation. It's not going to be like, $10,000 thing to have a meeting with an attorney who knows what they're talking about. Like, it seems like so much could be avoided if people plan ahead. Okay, Melissa, do you have any practice pointers?
I would really encourage people, I said this at the State Bar Roundtable too, encourage people to look at all of the statutes that were amended under this bill package, because the surrogacy portion got a lot of publicity and people are really interested in that because it's new, but there's a lot of stuff in the rest of these that's really going to impact, I think, more people on a daily basis, and especially people that general family law practitioners.
So like you talk about the assisted reproduction aspect of it is much more like impactful to a broader group of people than the surrogacy, right?
Yeah, well, and this was a package of 9 bills. So, there's now a statute that deals with genetic, not being able to use genetic testing to make a donor a parent, and just kind of a lot of different things that, I don't know, there's just a lot in here. It's taken me about a year to finally feel like I have a good understanding of what's where.
So if an attorney who has been working on this for years, like, and all of us here, like, we just like, it's a lot, right?
It's a lot.
So again, another reason to advise client, like, get your family members, like, tell them to go see an attorney, because it's not like something that's just very easy.
Yeah.
And Melissa and I were I was racking my brains, and Melissa didn't help much because she couldn't remember. I swear to God, there was a Kent County case years ago, like in the past 15 years at least. And somebody was trying to make a sperm donor a legal father for child support, and she doesn't remember it. I swear I thought she was involved with it, but I guess I was wrong. And I looked through all my files because I remember the family law section being asked to participate. I couldn't find it, but I think it ended up settling. So it didn't actually go to appeal. So we don't have an opinion. But there was it's like, wow, like we shouldn't have to have these conversations, and like, somebody who's donating sperm should not have to be on the hook to pay child support because they're not the intended parent, which I think maybe the statute clearly will definitely clean up that problem. So anyway, thank you to Alexis and Melissa. I will be sending something out after this. It may be till next week because I want to make sure we get Alexis's P number in there. And I'll identify a few resources. And we've had a lot of really good conversation with the chats and the Q&A today. So thank you everybody for participating. And thank you to Liisa Schmidt for pulling some statutes for us. I hate doing that when I'm in a webinar because then I have to leave, like you see me, but I'm not looking at the screen. So I don't want to go like do research while we're in the middle of a webinar. So I appreciate it. Everybody have a great day. Thank you so much,
Thanks
Melissa
so
and
much for
Alexis.
having me. Bye.
Yeah,
Good
we'll
to
hope to see you in person soon.
Yeah, definitely. Bye.
Bye.